Asset matter for inclusion, Your Lordship.
Give monthly list. Monthly list.
Yeah, permit,
Motion matter for inclusion.
I'm permitted to mention, Miller. Item number 20, the petitioner's advocate left for Delhi for urgent work. He will not.
Item number?
Item number 20. He was present before the court.
You don't want it today.
Lordship, kindly fix the matter on 9th of April.
In month of April, we are already in month of April.
Lordship, kindly fix.
What fix? It is at 20 number. You don't want to do it, then what fix? It is within reach and you don't want to do it, then what can be done? You are for the petitioner.
Petitioner, Mr. Tushar Ranjan Mohanty, advocate for. It will change bit. In the list, the name has not been changed, madam.
No. If the advocate on record comes, then only. Otherwise,
It is submitted in the department, madam.
filed
Yes, madam. Changed vocal number submitted in the department.
with NOC.
Yes, madam.
Let it be called. Ask them to get the Vakalatama, item 20. Yes, see if Vakalatama has been filed. When it is called, you mention.
Item number 1.
Lord, before taking up the case, my Lord, Mr. Chirodip Sinha appearing for the respondent, that is the original applicant. My Lord, Your Lordship may kindly adjourn the matter. Your Lordship, he is out of station, my Lord, on 8th subject to Lordship's kind sanction.
Yes. What is it? What is the issue?
The issue is that,
Lord, Mr. Sinha is appearing.
You have mentioned, yes.
the applicant was a deputationist, my lord. He was
a
deputationist, my lord. He was
deputationist
yes,
in
the post of boarding office, in the post of the writ petitioner, my lord, in an office of the writ petitioner, my lord. And after a number of extensions of such deputation, my lord, he was repatriated. Order of repatriation passed, challenging the same. The court passed an order asking him to give a composite representation. That was disposed of, and challenging that order, he filed the original application with the court. And he applied for absorption in the post of deputation, my lord, permanent absorption. And that has been allowed without adhering the extant rules and notifications by the learned tribunal below, my lord. If your lordships kindly goes to the impugned order, that is at volume 4, my lord, page 571. Sorry, that is not paginated. After page 576, 575, the original order is there, not paginated.
No, where is the reason? 30th November order.
Yes, my lord.
The order passed pursuant to the earlier order passed by the chairman.
Earlier order, my lord. Yes, my lord.
No, the order passed by the authority upon his representation.
Yes, that is at. Yes, my lord. Page 261.
261.
Yes, ma'am.
Volume 1.
Volume 2, my lord. Volume 2. Thank you, sir. Okay. Well, in the original application, this memo was not taken as a support. That's why,
Original application, it is not required to be. This is your rule.
yes,
Do you dispute that this rule does not exist?
but this, he was promoted before this rule came into effect.
That is a fact.
Yes,
Unless you raise that fact, how the tribunal will know it? That is why we are asking you.
Well, it was on the face of the.
Therefore, the tribunal should have read everything and passed the order in your favor.
Well, may I point out from my reply, my lord?
Please show from your reply or any your submission is also not recorded
My
to
lord.
this extent. What is wrong with the tribunal's order? Nothing is wrong. It is not your case before the tribunal.
One second.
Where in the show us from the order where you have made this submission that this is not applicable because he was already promoted. This does not apply to him. Where is this statement? Where is this submission recorded in the order?
But this notification came up at the time of hearing only.
Huh?
At the time of hearing, final hearing, this notification came up, my lord. That's why I could not deal with properly. But there is a memo, my lord, of 89, which the tribunal said is not applicable. But in that memo, it was clearly stated that absorption, unless it is
Unless the deputation order contains a stipulation that can be absorbed,
yes.
it will not be done.
Ma'am.
That was your only case.
yes, ma'am,
That was your only case.
and that
Where is that requirement under this 29/12/23
But
instruction? That requirement is not there.
No, no, the 23
This is as a special case 29/12/23.
This is not applicable to him because
That is not a point taken by you.
absolutely, my lord, I could not because this memo was not taken.
Where
as a
have
break
you
of-
said? Let us see. Where is your pleading in the writ petition that we could not raise this issue because on the last day it happened? Please show us.
One second.
Pleading has any meaning or no meaning?
May I come? One second. That in the form your lordship is seeking, or this is not there.
No, in
But
whichever form, let us see
But,
which form you have said
but in,
that we could
page
not
six-
raise this plea because it was never. And
But
how
that
do
is-
you know if it is not there, how you are making such submission?
well, since the circular is existing, my lord, the learned tribunal below.
How
has-
can you make a factual submission without pleading?
well, since this
All
was,
the factual submissions you are making without pleading.
well, since the
Neither you have stated before the tribunal that this does not apply, nor you have stated that we could not respond because it was produced on the last day. And we don't know how you are making all this. Then how can you? You cannot make such submission.
But this is a factual assurance.
We don't know this is a factual aspect. We can't. You are not. You cannot make out a case distinct from your client's case.
That
You are bound by the pleadings.
absolutely, man.
Then,
But since
since your client has not said, how can you say? You cannot say.
Well,
We will not accept such
but
submission.
this is existing, but
This is not
89 memo-
existing.
my lord,
Nowhere.
89 and it comes to 89 memo, my lord. Page 328, my lord. The relevant part of the HOD. Volume 3.
What is this 328?
They attached to our reply, my lord.
Huh?
328.
328.
Yes. Point number 10.2.
What is this? What are you relying upon?
My lord, 10.2, my lord, last 4.
Yes.
The original circular.
Is that ground you have taken? That is the only ground you have taken.
Yes, ma'am. And that one I'm arguing with Supreme Court judgments. Why
That is
it has
your
been
only
stated-
ground. There is no denial of this
Yes, ma'am.
23, whatever it is, letter. Then what can be done? The tribunal, how the tribunal has erred in deciding what it has? Tell us.
This is applicable. What is the
Huh?
tribunal said that this is not applicable.
Tribunal held this is not applicable. Where? Let us see.
Paragraph 4, page 5, my lord.
Of the order.
Obvious. Internal page 5.
No, this is recording the case of the parties.
No, my lord, kindly comes.
Applicant has filed a rejoinder to the reply. This is his submission.
Then comes to page 6.
Yes.
It deals with the same. And then, and the last part. Therefore, the respondent have taken censure.
No, where is the finding that this is not applicable? You don't find any such finding.
After that, my lord, page 8, paragraph 10, last part.
Page 8.
Yes, page 8, paragraph 10, last part. It's not applicable for the case of the applicant. He made the 23 notification applicable and not this one.
So it has relied on a rule
Yes,
rather than relying upon an office memorandum. What is wrong with that?
my lord, 89, my lord, is subsisting, my lord. It has not been superseded by any
The
subsequent.
rule will prevail or the office memorandum?
My lord, the office memorandum has not been, it does not.
Again, we are asking you, a rule will prevail or office memorandum?
Office rule will prevail, my lord.
Then
Absolutely.
what is wrong with it?
Applicable to him.
There is nothing wrong.
It was earlier promoted. When the rule came into effect, my lord, prior to that, my lord, he was
When the rule came into effect, shows
29 December 2023.
Hmm?
29th December 2023.
No, that is not the rule, sir.
Which has,
That is not the rule.
which has been applied by the Lord's
The
tribunal.
rule is of 2016.
Yes, but that's rule, but I'm not saying that rule.
When was he promoted?
It's 2018.
So therefore, rule came into force on 2016.
Absorption, not absorption is something else, my lord. Subject to correction, my lord.
Yes.
Cannot be, is not a matter of right, my lord. Well,
It has examined the rule.
yes,
You say that ignoring the rule, they should rely on the OM. Why?
no, I'm not.
There is an OM of 89 or 98 and rule has come in 2016. The OM will prevail all the rule.
Kindly comes to 2016 rule, my lord.
Huh?
Kindly comes to 2016 rule once.
2016 rules.
Yes.
Where is it?
In page
Let him appear, then we'll consider. Yes, when he will appear? You- Who is to appear?
Mr. Chirodip Sinha appearing for the applicant, my lord, and here in respondent, he is out of station, my lord, only subject to lordship's kind sanction. If your lordship takes up the matter on 8th, he will be available on
We
that.
cannot fix a date for him. We'll take it up after.
Any
the
date
week.
subject to lordship's sanction, any date.
Monday, I have some document.
Take it up on Friday as paid list on 11th.
Good.
Item number 2.
My lord, I am for the respondent, my lord. The last occasion, your lordship directed them to verify whether those applicants were parties in before the learned tribunal, my lord. They have made an application for addition of party. Your lordship directed them to verify whether those persons were parties before the learned tribunal, my lord.
Can?
They had to confirm that, my lord.
My lord, I am appearing on behalf of the senior counsel, Mr. Vikas Ranjan Bhattacharya, who is appearing in this matter for the petitioner, your lordships.
Yes.
Your lordships, he is not available in the town. On this account, I am seeking an adjournment. I'm praying for an adjournment for 2 weeks, my lord, so that the matter can be heard in his presence.
My lord.
As paid by current council for the petitioner list after 2 weeks.
Grateful, my lord.
Number 3.
Lordship, I'm led by Advocate Shobhoshachi Chatterjee. Lordship, he is engaged in code number 35, Lordship. Lordship, I'm praying for not today, Lordship. Kindly fix any date, Lordship, in the next week.
No, I asked.
Item number 5.
Your Lordship, in this matter, I am appearing for the respondent on the last In this matter, Your Lordship, I'm for the respondent. On the last occasion, Your Lordship has the LC was called for, Your Lordship. And Malit, the para 6 of that particular order impugned herein, Malit, it was not legible. So therefore, Your Lordship was pleased to direct to take the LCA, Malit. I just want to show, I want to just read that particular part, Malit, so that I can come back with Your Lordship on Monday for final hearing, Malit. Because even I'm oblivious with that particular paragraph, Malit, which was written in the order impugned, Your Lordship. Your Lordship recorded that particular fact in paragraph 4 of Your Lordship's last order. Excuse me. Bharat Bhushan. Bharat Bhushan for respondent. LCR call for which, my Lord Diksh.
We find that the
Deep request.
Number 6.
Instead of respondents, say petitioner and respondent both. Learn counsel for the petitioner and respondent. What happened?
I'm led by Mr. Sophie Londi, madam.
Yes.
Having short pass.
What is it?
Land loser matter.
Land loser matter is out of. Some has been appointed, some has not been appointed.
What is the issue?
The 2010 circular of the railways held that if your land is taken, in that case, for acquisition purpose for the railways, then one from the family will get appointment under the land loser category.
Yes.
Criteria were laid down. Initially, orders were passed, my lord, by the learned tribunal that within 3 months you consider the case and take steps. After that, appointments were given in certain cases. About total 446 persons were given appointment. But then the railways did not proceed when contempt was filed. In the contempt, a rule was issued. That rule was challenged before the High Court. The High Court dismissed it, and the contempt was to be proceeded with before the learned tribunal. The learned tribunal heard the matter and dropped the contempt proceedings on a peculiar circumstances. In similar matters, we came before the High Court, and the High Court directed, no, you cannot do this. You have to give appointment. Now, my lord, I'll show your lordship. May I proceed, my lord?
The sequence of events that you have narrated is common to all these matters.
Yes.
The only issue is on what ground they are resisting your claim. There are, until now, we have seen some grounds. One is that PET
Overage.
not qualified, other is overage.
Overage.
PET not qualified.
PET not qualified.
Yes.
And the other one is less qualification other than matriculation. These are the three. This has all been decided by this honorable.
So which is the issue being raised here in your case?
My lord, because there are several petitioners in this matter, my lord. Now, ultimately, they have held that way and given an affidavit where we have given a reply, my lord. If your lordship takes up the reply, it will be easier for.
We are asking you what is which under which clause you are being not considered for not qualifying PET, for not having minimum qualification, for being overage. What is the criteria?
My lord, in some cases it is overage.
Oh, so there are many petitioners.
Because contempt was number of people had moved and a common order was passed. Let me show your lordship first the rule that was issued by the learned tribunal.
That is not very material. That's not relevant. The point is we must know who has been disqualified or who is not being considered on what ground.
Page 10 of my affidavit will show my affidavit in reply.
Why do you club so many people in one? It becomes impossible to consider anything.
There it was because
Composite order, that does not mean a composite writ petition has to be filed.
Because my lord, no, not that way. All of them were petitioners before the learned tribunal.
In one petition.
That is why. Otherwise, my lord, we have to file separate.
We can understand if there may be more than one petitioner, but if all are being not considered on the same ground. But where the grounds vary, how they can be clubbed together?
No, because now they have disclosed this because the contempt was dropped, my lord. Contempt was dropped, and
when you approach the tribunal, you must be knowing on what ground you are not being considered.
What they did was, they were saying PET, overage, etc. Different points they were
So
taking.
therefore, everyone must have been faced with some kind of issue. So why they have all joined together in one application?
Because, my lord, the order is in one petition, they have passed this order. And, my lord, there are, in this petition,
Where is the reply? Which page you said?
page 10, my lord, of my affidavit in reply. Hmm. বলছি। My lord, in total, there are 16 petitioners in this matter. Out of them, some have already been granted appointment. Some, my lord, have been called for PET today. DV, I'm sorry, PET. For document verification today. When the matter is coming up before your lordship, they have asked 4 of us to go before them.
Let us see what they do then. Then you come back.
Lordship.
In the meantime, you make about, at least on a page, make out which petitioner is being not considered
But
on
it's
what.
there. In
It's
the-
not there, not this way.
Yes,
For
my
all
lord.
the petitioners, serial wise. You give number 15 at the top and you give the lower number at the bottom. How do you expect us to examine this?
Because I'll do that. I'll do that.
Please be kind to us, sir.
No, don't. Lordship will not take with that. My lord, in the next matter also, my learned friend is there.
Number
Both are to
7.
be
Same.
6 and
7.
Here, my lord, all are overage.
Oh, so that issue is not there, but some are being considered.
Probably,
Yes,
huh?
already got appointment, some of them.
Some have got it already, and some are overage, and they have filed the affidavit to say so. But then, my lord, I think your lordship will take
List
up.
along with, just in the next case, the court and order list along with the earlier.
Lord, could it be made 9th, my lord?
We don't think so. Please have a look at the calendar. 9th may not be possible.
9th, that is holiday, Rabindranath Tagore's birthday.
My lord, then 14th, my lord, subject to my lord's.
Yes, 14th can.
I'm grateful.
Ninth April, 9th May.
Number 8.
That I appear for the petition.
Your lordship, for the respondents. Eastern Railway.
Should-
Filing
That
my,
yesterday, my lord, they served the opposition, my lord. I need 7 days time to reply.
It's coming up for the first time.
no, your lordship.
Third,
You are filing it today. Affidavit
yesterday it was
in
third.
opposition. Yes.
Kindly give a,
Immediately after 21st, my lord.
kindly give a date.
Kindly,
Give a date.
after a week, he is saying after 21st.
Next week is, next week, 16, 17, 15, 16, holiday.
16, 17, there is
16,
working.
Working.
There is
17 minutes, 16. So have you? 21st minute, 22nd.
just now we were saying between 21st to 2nd, we may not be here.
Oh, I'm sorry. I'm sorry. I apologize. 23rd.
21st to 2nd, we will not.
Oh, then 3rd May.
3rd May is
5th May.
Saturday.
5th May.
8th May.
5th May. I'm
8th
deeply
May.
obliged. I'm extremely grateful.
Instead of a week, 6 and adjournment list on 8th May.
5th May. 5 तारीख 8 8 अच्छा 8 में खोला है
बोला
Number 9.
Your Lordship, 9 to 12 are similar matters. My senior is out of town any day after 12th of. We have filed our exchange our affidavits.
Let us see what is the issue. Same.
Land losers.
The present
Number 13.
13 and 14 same.
all same order.
Union of India.
It will come on 14th May. 14th. Something is to be filed.
No,
exchange, my lord.
they have not chosen not to in one case. Others already there.
I have filed.
Huh?
But they can, if they want, they can. If you want, you file.
14th May. 14th May. No. Sorry.
In respect of 14 May, we have exchanged the affidavits. Item number 16.
We're having it on the same day.
I'm not 16, we are for the respondents, my lord.
15.
16.
Sanjay Kumar.
Yes, what is the issue?
Doko Paisa. It was stated that he suffered from cardiac stop. It was not possible to what? Doko pilot that was degraded. But he was posted at 2 months. That is after that. But the railway board circular,
None appears for the petitioner. A list after 4 weeks. 4.
Item number 17.
6 May. 6 May. Your Lordship, 17, I'm for the petitioner. This is relating to Defense Department.
You are appearing in 16.
Praying for accommodation, my lords, because Mr. Rai was leading me, my lord. I'm sorry. But
17 for. Instead of none appears as paid.
My application, Your Lordship, we had served the respondents, private respondent army officers. This is pertaining to disability pension of army.
Where is the affidavit?
Your Lordship, affidavit of service, I have not been able to prepare. Your
Right, there is a direction.
Your Lordship. My counsel was appearing. He was there yesterday. Kindly keep it for Monday. I'll
Not today.
much of it.
Two cars. The entire road was clear. Only the side. Only there is park.
I appear on behalf of the state, Your Lordship.
Yes. Supplementary has been filed.
Your Lordship, opposition has been filed, Your Lordship, and served, Your Lordship. Reply has not been filed yet. Your Lordship, in any event,
No, there was earlier a direction to the petitioner to file a supplementary app. Not been filed.
affidavit in no such affidavit or any affidavit in reply has been served upon us. But in any event, I have been told by the
You are being told?
by the junior of the learned counsel appearing for the petitioner that he is perhaps undergoing a treatment in Bangalore. Yesterday, the junior informed us.
Can we record this?
No, it's just
Not today. Let's see what happens on Monday.
yes.
Today all the matters are.
Number 19. Item number 19. Lord, I am led by Mr. Devashish Banerjee, bear the petitioner, Lordship. And it's hot password. He is the code room number 17.
Start. He will come. Let us read the order. He is not.
My Lord, regarding the nurses promotion, my Lord, earlier, this matter regarding to nurses promotion, my Lord.
Nurses promotion. What happened? Promotion is not being granted.
My Lord, in earlier one petition, my Lord have passed the orders Same, the same
have passed the same order.
WPST 195 of 2024, Lordship.
Oh. Trainee reserve, the trainee reserve matter.
Yes, Lordship.
Yes, there was some distinction in this matter from the other. What was the distinction?
Lord, in earlier matter, he was promoted and joined the promotional post.
Here before joining the
He
letter
cancelled
was
the-
issued.
Yes, ma'am.
You have got the order passed by us in the earlier case.
Yes, Lordship.
You have the order. No, no, don't give us that.
Short password.
What is the case number?
WPST 195 of 2024.
Okay, 2 copies. 2 copies. 2 copies.
I'm led by Mr.
My lord.
You have copies.
Reserve matter, my lord, we had handed up, my lord, the earlier order passed in the earlier case, as well as the, my lord, the typed copy that your lordship,
You have given us.
my lord, one page typed copy. No, no, that's the.
This one.
My lord, this one, my lord.
No, where is the copies of the order that we passed in the other case?
On a stitched copy.
One minute.
One copy. There will be two stitched copies, my lord. There are two stitched copies, my lord.
Okay, he's saying the written mistake. There's no organized file.
So she proceeded for the trainee reserve on which date?
My lord, the trainee reserve order is at page 51. The trainee reserve order was issued, my lord, 16th of March 2022. But my lord, I joined the course, my lord, prior to that, 9th of February 2022.
Even prior to issuance of the order?
My lord, provisional TR is given, my lord, first, and then, my lord, the formal order had passed.
So 16/3 is the relevant date.
My lord, 16th of March 2022.
Yes.
The formal order of trainee reserve was passed.
And then she participated in the the promotion process.
Then, my lord, I participated in the promotion process. I submitted my biodata as directed, my lord.
It was seniority based.
It was, my lord, seniority basis.
And then where is the order promoting you?
The promotion order, my lord, at page
24/8/22.
My lord, 24/8/22. I'm grateful. And my name appears at serial number 187.
So staff nurse grade 2.
My lord, staff nurse grade 2. To my lord, staff nurse grade 1 within bracket 2.
And this promotion also contemplated joining at a different place.
Joining at a different.
Which place?
My lord, though it is in the same district, but it will be, my lord, Nazirpur Block Primary Health Center.
Nazirpur. Nazirpur Block?
Block Primary Health Center.
And where was she prior to that?
Prior to that, my lord, she was at, my lord, Tehotto Subdivisional Hospital. Tehotto Subdivisional Hospital. Both are in the district of Nadia.
So when the promotion order was issued on 24/8/22, she went to join?
My lord, I took release.
Release from Tehotto?
First, I took release from the, my lord, superintendent of Tehotto.
Yes.
My lord, thereafter, my lord,
On what date you got the
my lord,
release?
I took release from the superintendent on 26th of August 2022.
Then?
Then, my lord, I joined
Nazirpur Block.
My lord, my lord, what happens, my lord, in the block, my
The
lord,
directorate. You have
join at the office of the CMOH.
CMOH.
My lord, that, my lord, joining, my lord, kindly sees at page 58.
Yes.
And then, my lord, this order on 29th of August 2022 was issued by the CMOH.
58. Page 58 is
58, my lord, joining at CMOH.
allowed to join on 29/8/22.
29/8/22.
Then what happened?
And then, my lord, page 59, CMOH releases me for joining at my promotional post.
On the same date?
On the same day.
Yes.
Now, my lord, before I could join my promotional post, this order was, my lord, issued on 31st of August 2020.
Where is that order? Which page?
My lord, page 60. 31st August 2022, my lord. This, your lordship, this order, your lordships have, my lord, quashed in the earlier writ petition.
Yes.
My lord, pursuant to this order, my lord, my joining was cancelled. That is at page 61, which was, my lord, not a legible copy. My lord, I handed up a legible copy.
So the consequential order is at page 61.
61.
Politics. Here is also not here. Send history. We have already passed an order in one case, Mr. Mukherjee. Is that trainee reserve matter?
Yes.
Only difference here, prior to the joining being accepted, it has been cancelled. There after the joining, it was cancelled.
But only difficulty is whether his joining report was cancelled. And seniority has to be determined under the seniority rules 1981. From the date of joining.
From the
Date of joining.
seniority, we don't know. That's not an issue here.
No, once seniority from the date of joining.
There's no issue of seniority as of now. Whether she can join or not, that is the only issue. There's no issue.
If somebody gets an opportunity to undergo a course at the cost of the state government, he cannot be present both at the hospital as well as
That aspect we have considered already. That we have considered.
we have got the rules. Ministry of Senior rules. Kindly see.
What rules?
The West Bengal Services Determination of Seniority Rules 1981.
Seniority is not an issue here. There is no issue of seniority. Whether while being a trainee reserve, she can be permitted to join the promoted post or not. That is the only issue. There is no issue of any seniority arising.
No, but she has been promoted while undergoing a training. Then immediately then got an information that because your joining is cancelled because of this.
That we have seen.
So then whether we will give the promotion from the date of joining or from the date of
No, your government's decision is that only after the trainee reserve period is over, then only she can join. The government has taken a decision that after the trainee reserve period is over, then only she can join. That we have seen. We already decided.
The kindly see trainee reserve rules.
Huh?
Trainee reserve rules.
Trainee reserve rules. Yes, we have
Other
seen
than
that. We have.
The lordships have
The
considered
last
that.
case we have considered everything.
Yeah, considered in that aspect, but hard transfer order was not cancelled.
So that is a distinction.
Between the two
That
facts.
is a distinction.
So for other facts decided by your lordship until the is certified or stayed by the High Court, that is binding upon us.
Yes.
So far, in this present case, her joining report was cancelled. And
Yes, she went from Tehta, she went to Nazirpur. Nazirpur CMO accepted the joining. CMOH relieved her to go to the Nazirpur, and then before she could reach Nazirpur, you said it cannot be done.
Yes.
So here also she has joined before the CMOH.
I'm grateful.
But joining report has been cancelled.
Correct. So there only it is the same thing. There is no difference.
But
there also she had joined. She had joined not only in the CMOH, but she had joined at the place of posting also.
But
Here it is one stage before that.
Yes.
She has joined at
distinguished facts only this aspect, no other fact. And whether the determine my lord friend wants a seniority also from the date of initial joining.
We don't know what you will do when that issue comes. What you will do, that we'll see.
Kindly see that.
That is not an issue arising today.
That is the,
if you had said in your order that you will join, you will get everything, but you will not get seniority, then it would have been an issue. That's not your case. You say it cannot be joined. So that is the only thing.
Kindly see that.
You could have said that you are joining on a promoted post, you will not be working, therefore you will get all benefits, but seniority will count from the day you assume the charge. We don't know it would have been sustained or not. But you could have done this, but you have not done that.
This cancellation, my lord, my understanding was issued, my lord, on the presumption that maybe during the MSc course, these nurses do not have to, my lord, work. But my lord, the course is like this, my lord, from morning till, my lord, mid of the day, they have to, my lord, perform the duties as a nurse in that nursing school attached to the hospital. And then, my lord, for 2 hours or 3 hours, they have to study. So, my lord, the course is like this, they will have to, my lord, work as a nurse in the attached hospital.
No, but their objection is you will not be working on the promoted posts.
That is one thing, but the primary objection here and before the tribunal also, that they will not work and how they will be, my lord,
everything
get
is
to
similar,
benefit.
only distinction is here at one stage prior to the earlier
I'm
case,
grateful, madam.
there is a
Only thing.
cancellation.
But I joined at the office of the CMOH and that joining was allowed. And thereafter subsequently cancelled.
Joining order has been cancelled. As soon as joining order is cancelled, that means he will be as a trainee reserve in the government of West, because he was getting pay from the state government.
Correct.
But he is not discharging duties as a
Yes,
government.
that is the same stand you have taken in the last.
No, what I here case, when as soon as the joining report is cancelled, he is prosecuting her studies at medical college, not at the hospital.
Correct. The objection, my lord, not at the promotional post or the, my lord, prior post. She is not working. This is, my lord, wrong.
He has not
No,
worked in the
his objection we have recorded in the earlier case. It is relying upon quite a settled principle that the benefits attached to the promoted post can be available only when you join the post and you perform the duties. Since you are not performing the duties, you cannot claim. And you are taking the course for bettering your future prospects. Therefore, you cannot have both. This is what he has argued.
My lord, the nature of duties at my promotional.
But we are also bound by the earlier order. So we'll be passing the same order.
Grateful.
But only difference that can be clarified.
We'll consider. Don't worry.
The rules may be
the earlier writ petition only. And that is the reason, my lord, TR rules were annexed.
Give
there.
us a copy if you have a
TR rules. Sir.
TR rules.
ATR rules. 2009. And other determination of seniority rules. Rule 4 sub rule 5. Rule 5. Download project to me. Sub rule 3 of 2009.
Rule 5.
5, sorry, rule 4 sub rule 3. Small a Roman 3.
For postgraduate courses of 2 years duration or less.
Based on tendencies for prosecuting any court in any such manner as laid down on subclause 2 of this clause shall not be allowed to any other facility.
We don't find it. Where are we reading?
4 of 2009 rule.
No, TR rule is of 2015. What rule?
2009 rules, 8th October, December 2009 published.
3rd June
My lord,
2015.
what, my lord, 2009 rules, TR rules, what my learned senior is placing, my lord, rule 4, sub rule 3, Roman 3, which,
Small a Roman.
which says, my lord, nursing personnel once placed on a trainee reserve for prosecuting any
But
course.
where is the 9 rules you have given us?
2009 rules.
In 2015. There are 2. There is one more.
Not the 2009 rules.
But I don't have it.
I have a copy, but my lord, that is
Just
annexed.
see, Mr. Mukherjee.
That is
Just see. Show him.
Sorry, my lord, I have wrong.
Wrong rule.
2015, my lord, is the TR rules for the doctors.
4 sub rule 3.
4 sub rule 3.
Small a Roman 3.
Nursing personnel once placed on trainee reserve for prosecuting any course in such manner as laid down in subclause 2 of this clause shall not be allowed any other facilities of trainee reserve for prosecuting similar course. So, my lord, at a time, one trainee reserve cannot do 2 courses. That is the embargo.
No. Any other facility, but that means
Facilities
benefit.
of trainee reserve.
How can you get promotion
Of
to be?
trainee reserve. Once taken trainee reserve, my lord, she or he cannot, my lord, be entitled to another trainee.
This means that you can take this facility only once.
My lord, once at a time.
No.
Yes, because my lord, kindly sees once placed on trainee reserve.
It can never be once at a time because no full-time course can be pursued
simultaneously, but there
Therefore,
are certain courses, my lord, diploma courses, which I do not need to attend, but still I can do. My lord, probably, my lord, to my humble comprehension, my lord. Any other discipline unless permitted by the state government.
Any other facility, that is the very touching part.
Any other facilities of trainee reserve.
Yes, so that means only once you can get it.
And second, my lord, second time only with the permission of the state government. I had placed, my lord, rule 5, sub rule, my lord, 2. No nursing personnel shall be allowed to resign or retire voluntarily or deputed to any other service or to be placed in lien during the period of service required in the bond unless she has paid such amount as specified in the rule 1 of this rule.
that issue. No, no.
If I had to, my lord, resign from the TR or the course, I had to, my lord, then pay this penal amount. And sub-rule 3 also, my lord, 5 sub-rule 3.
Yes, that she has to pay money.
She has to pay money, and then, my lord, she will not be entitled for any other trainee reserve in the future.
Yes, 5-2 and 5-3 we have considered.
My lord, my lord.
4-3 perhaps we have not considered. But what Mr. Mukherjee is now arguing, that he had not argued in the earlier case. 4-3 was not argued in that case.
Because in that case, he continued in the promotional post and joined in the post. Her service was not terminated.
No, her service has also not been terminated.
Joining report here is cancelled. In that case, joining was there, then he has challenged the order. But he has also challenged the order of the Director of Health Services, which was the main order.
No, in sum and substance, it is the same thing. It says you cannot. Either you leave the course or you leave the promotion. That was the order of the director. Either you leave the course. Page?
61 of the Deputation, madam.
Yes.
Cancellation of the joining, madam.
Cancellation of the joining.
We'll see. Yes, that was not legible. He has given a legible copy. Of that order, he has given a legible copy. You have given him.
Is cancelled. Then what is the status?
Very good. The status is that she is not considered a promoted nurse. Yes.
Oh, he has considered as a trainee reserve.
Correct. So she is not considered as a promoted nurse.
Ah, yeah.
That is what we are saying. She is not considered as a promoted nurse, or she continues to be a trainee reserve. Both are the same thing.
Huh?
Page 60. Feel like writing such a long.
And determination of seniority rules are placed before Lordship.
No, that we don't want to. There's no issue of seniority. Neither they are claiming nor you are denying. There is no order that you will not get seniority. You are only saying that you will not get the benefit of the promoted post. That's all. You could have said that if in such circumstance you join on the promoted post, seniority will not be granted. Seniority will be determined from the day when you discharge the duties. But you have not said anything like that.
School is applicable to her.
It will. Who is saying? She is not saying that this rule will not apply. We'll see. This rule may be applicable, but the rule, the TR rule is also a rule framed under the proviso to Article 309, and that covers a special circumstance. So generally, a specialibus non-derogante, you know.
And two rules are framed under 309.
And one is for this specific purpose, for trainee reserve.
Special rule.
For trainee reserve.
And this rule is for all.
That is general seniority rule for applicable to all.
State government employees.
After these two cases, my lord, now they have, my lord, corrected their stand. Now the promotional orders, my lord, they have this clause that candidates presently placed on trainee reserves are allowed to join their promotional post only after the completion. Now, from now onwards, after these two cases, they have rectified the promotional orders
Without amending the TR rules.
without amending the TR rules. So if somebody challenges,
We don't. We are just asking the facts. We are not for orders.
Lordship, I have mentioned the matter at the time of sitting for fixation.
Behalf of some advocate that he has filed a wakalatnama.
Mr. Tushar Ranjan Mohanty.
Huh?
Tushar Ranjan Mohanty. I have submitted the copy of the wakalatnama.
Wakalatnama is not here. Wakalatnama you have not received. Wakalatnama has not been received. You want? Why it could not be brought? It's here. He has filed it. Yeah, I don't know. That's right. Anyway, how much time do you want? How much time do you want?
Lordship, kindly fix it on the 9th of April at the top.
Number 21.
Item number 21, my lord, I am for the petitioner, my lord. I am for the respondent.
Yes.
Yes, my lord. This is my application challenging the order dated 6th October 2023, my lord, whereby the Learned Tribunal has directed the respondent, my lord, the applicant Sri Paresh Chandra Mondal is entitled to receive the balance standing at the GPF account of the deceased employee late Manik Mondal, my lord. Our difficulty is, my lord, we are ready to give the GPF amount, my lord, but subject to the submissions of the succession certificate, my lord.
He was nominee.
He was nominee, my lord. My lord, first of all, my
So
lord.
nominee also has to give a succession
Yes,
certificate.
my lord. May I, my lord? First of all, my lord, kindly come to page 93, my lord. We have
See, the deceased, the government's employee had nominated his mother and
mother and
brother.
brother.
Mother has already passed away. Brother is the nominee who is surviving. There are other 7 legal heirs. They have also given their affidavit that they have nothing to do. It may be given to him.
My lord, kindly come to objection, my lord. We have received a objection letter, my lord, at page 93, my lord. Even they are, my lord, claiming that they late Manik Mondal was our direct blood related, my lord, uncle.
They are not. Actual legal heir, my lord.
Yes, they are nephews. How
My
how
lord,
they
yes,
have
my
any-
lord. I'm coming, my lord. My lord, then kindly come to supplementary affidavit, my lord.
Yes.
Page 33, my lord.
Yes.
B, if the whole sum or balance, as the case may be, does not exceed 5,000 rupees, pay the same or any part thereof which is not.
Where are you reading?
My lord,
B.
page 33.
B.
B.
At the top.
Top. May I, my lord? Or any part thereof which is not payable under clause A to any person nominated to receive it under the rule of the fund, or if no person is so nominated, to any person appearing to him to be otherwise entitled to receive, my lord. If not exceed, my lord, 5,000, my lord. Now, my lord,
What is this? From you are reading from what? What is this?
my lord, this is the part of Provident Fund Act 1925, my lord. My lord, then my lord, C, in the case of any sum or balance or any part thereof which is not part to any person under clause A or B, pay the same. My lord, Roman 1, to any person nominated to receive it under the rules of the fund on production by such person of probate or letter of administrations evidencing the grant of him of administration through the state of the disease, or a certificate grant under the Succession Certificate Act 1889, my lord. One point three. My lord, now, my lord, in the appendix B of the memorandum explanations of the government provident fund rule, vice versa, the law of the subject, my lord, kindly come to page 37, my lord. In the appendix also, my lord, it has been clearly mentioned, my lord. Page 37, my lord, that is serial number 6, Roman 2. May I, my lord?
Why you have skipped A? Why you have read B directly? Why are you omitting 4 and 4A? What is the effect of 4A?
My lord, if the
Because when you read 4B,
yes, my lord.
it says which is not payable under clause A. Only if it is not payable under clause A, then this is to
Then
apply. So why you should be reading clause A also?
yes, ma'am.
What does clause A say about dependent widow and the son? Just see.
If the sum or balance or any part thereof vested in the dependent under the provisions of the section 3, pay the same to be the dependent or to any such person as the may be authorized by
So
law.
dependent under section 3.
Section
See
3.
what section 3 says. 3(2). Any sum standing to the credit. Read 3(2).
Any sum standing to the credit of the subscriber to
Of any subscriber.
any subscriber to or depositor in any such fund at the time of the disease and payable under the rule of the fund to any dependent of the subscriber or depositor or to such person as may be authorized by law to receive payment on his behalf shall subject to any deduction authorized by this act and save where the
Save where the dependent is the widow or child of the subscriber or depositor.
my lord, he is not a child, he is the brother. My lord, he is not a direct dependent, my lord.
Oh, he is a brother, he is not son.
No son.
Unmarried.
My lord,
He's
Mr.
no-
Malik
he's no
Mondal
family.
was
That's why
have no family, my lord. He is a single, my lord. So, my lord, the respondent fell in
brother is the only
B, my lord.
blood relation.
Oh, you are not the son, you are the brother.
Brother, my
Yes, my lord. No, there is no family. He's the only nominee. That's why he
My
is
lord,
only nominee.
kindly come to page 37, my lord. This is the part of the appendix B, my lord. Roman 2, my lord. Roman 2, my lord, there is no family and there is a nominations in favor of a person who is also not a dependent. Payment will be made to the nominee if the amount does not exceed 5,000.
Where is your provident fund rules? State government's provident fund rules. Where is that?
Annex.
Why are you reading from the Provident Fund Act and these provisions? Where is your GPF rules? What is the provision in your GPF rules? It is in the DCRB or it is somewhere else?
My lord, Provident
My
Fund
lord.
Act.
This is the state government GPF rules.
State.
General Provident Account.
I miss central services.
Why should you read central services? You are a state government employee. Under 5.
পেমেন্ট মোটা বইটা কোথায় এগুলো রাখবে GPF amount, General Provident Fund.
Everywhere. So the fund. It must be there. Then that's a PCR. Yes, on 5. You have not seen 5. Tribunal has relied on some rule.
Yes, madam.
Where is the tribunal's order that is?
I have a tribunal order.
Oh, this is Central Administrative Tribunal.
Yes. সিনিয়র নেই নামটা দেবে সুমিত স্যার আছে তো অ্যাসুরেন্সটা নাম আমাদের হচ্ছে দিদি
Have the CCS GPF rules?
Yes.
Yes. What is this that you are relying upon?
My lord, I'm relying upon the Provident Fund Act 1925, my lord.
25.
Yes, ma'am.
Why you are relying on 25 Act?
My lord, even that is alive, my lord.
You are guided by the rules. Yes, this will be. Yes, take down.
My lord, last, my lord.
Yes.
My lord, even the respondent has submitted a succession certificate, my lord, before the learned tribunal, my lord. That is at page 30 of my supplementary affidavit, my lord.
Of your supplementary.
Yes, my lord.
Then what remains?
My lord, just I want to indicate, my lord, this Provident Fund amount is not mentioned in this. Page 30, my lord. Descriptions of asset.
Page 30.
Page 30 of my supplementary affidavit, my lord.
Yes, that was required for some banks, so he has got it for the bank. Yes. The
But 22.
Mr. Kapun Kumar.
Then next day, here, adjournment now. Thereafter again, today again. When the matter was last taken up on 20. The learned AGP is present. The learned AGP.
Item number 23.
I am for the petitioner, my lord.
I am for the respondent state. Lordship, on the last occasion, Lordship has directed them to file a supplementary affidavit because there was something wrong with the prayer portion of the petition. But usually I don't point out, but there has been certain mistake in the supplementary affidavit, which I think I should mention it before your Lordship.
Where is the supplementary?
This is the affidavit of service, my lord. Earlier date on 21st March, that was not served. And this is the supplementary affidavit. ওটা affidavit of আরেকটা copy ছিল না এখানে।
Two copies.
এটা affidavit of service.
Sonal Sinha. Showed up.
Principal accountant.
Yes. Yes.
And this is a very short case
Yes.
that the petitioner is a very poor person whose father was earlier was worked at Khalasi and who after that due to on behalf of a circular government circular became the worked at establishment. And then, my lord, after completion of 27 years,
Khalasi is entitled.
on
Where show us
due to,
which
due
rule?
to carcinoma, he died.
Where, from where? Show us. On the basis of which rule you are saying that the dependent of Khalasi is entitled to compassionate appointment? Which provision? Show us. A work charge Khalasi, he is entitled to, his dependents are entitled to compassionate appointment. Where is the provision? Where is the provision? Show us. Where is the provision on which you are relying? Show us.
There are so many cases in the compassion.
One, just show us one. We don't want so many. One, just show us one. So many is not required. One is required.
We prepared RTI, my lord, Right to Information Act, mentioning four persons, and out of them, one.
It is in the, it was before the tribunal. Was that document before the tribunal? We are not going to take any document which was not part of the tribunal's records. Show from the tribunal's record what case you have made out.
My lord, kindly give me time or next some date. And
Enough.
Fixed one date, my lord.
This is the only issue. There is nothing new that we are asking you. You have filed the case before the tribunal. You are here. Why? For what time?
No, my lord, actually,
Nothing can.
one Mr. Paul will submit.
Sorry. Land Council for the petition.
Item number 24.
It will take some time, my lord. If your lordship fix any other day, because 2 p.m. I have a matter.
Let us see what is the issue.
My lord, I am filing the reply.
Yes.
Deputy in reply, my lord, in the
Where is the order in WPST 1803?
803, my lord. At page, my lord.
'97. Yes.
Well, lordship kindly come to, thereafter, my lord, lordship kindly come to page 90. Thereafter, I'll come to, my lord, page 52. I have to file, my lord, contempt application. After contempt, filing the contempt application, this is the order. And the undersigned is directed to, by the order of the governor, to say that the governor is pleased to transfer one post, homeopathic medical officer, out of 545 posts of homeopathic medical officer sanctioned for the state of homeopathic dispensaries, and the same was disposal of the Calcutta Homeopathic Medical College and Hospital temporary with the immediate effect and accordingly the number of the post medical officer for the state homeopathic medical dispensaries shall be reduced to 544. And this post was created not now, my lord. This was created in 1986. So the Honorable Division Bench directed as and when the post is available. This post was created in 1986. I'm showing that, my lord, from page 52, losses kindly count.
So it may be, even if it is created in 1968 or 86, what difference does it make?
My lord, I'm submitting, my lord. It will take time. My losses kindly come to page 52.
There may be 1,000 posts created,
Yes, my lord.
but the point is when the vacancy will arise, then only you will get an appointment.
My lord, but
Yes.
I was working, I was appointed in 1981
As
a homeopathic medical officer in the Calcutta Homeopathic Medical College. And I had been working.
on contract.
No, my lord, regular basis. That time, my lord, private college. My lord, I'm submitting, my lord, I will complete it. I will come to my lord. My lord, subsequently thereafter, after taking over,
When after when you are
it
saying
was taken over in 1982 by ordinance and by act in 1983. That will come, my lord. I have in reply, I have everything annexed. They also annexed in opposition. And losses kindly come to page 52. One of the medical officer who was junior to me, working with me in that time, my lord, he filed a writ application in 1986.
yes,
My lord, that is the rule is dispensed with the terms of the agreed minutes of the court and signed the same. The petitioner number 1, Prashanta Kumar Das, and the petitioner number 3, Operis Bhattacharya, be absorbed as a medical officer according to the Homeopathic Medical Council Act 1973. The Calcutta Homeopathic Medical College and Hospital, the college authorities are directed to pay their salaries in accordance with the salaries fixed by the state government. The college authorities are further directed to issue the formal order of absorption in the pursuance of the order passed by the Honorable Court within fortnight. This is the Malad order, because he was after acquisition, after taking over the management by the Act, only it was the order in 19 next after 3 years. Similar circumstance.
it was not ordered, it was agreed between the parties.
Yes, Malad. Yes,
There's no direction.
Malad was suspended. Then Malad.
Only the agreement which has been recorded in minutes that has been taken note of by
Then
the.
thereafter, Malad, the similar, yeah. Malad also has seen my case also, Malad.
Yes.
And they said that it is similar circumstances, he will be absorbed on similar circumstances. So, Malad, my graph is, Malad, 1 year, 1 month, something days, Malad, for completing the 10 years.
That person.
Malad, that is, Malad, that is my
person,
past service was not counted.
the person with whom you're counting, claiming parity, that person has approached the court when?
But then, Malad, I'm
in 1986. You have been sleeping over your rights till 2001.
No, 1988, I have filed writ application.
Yes.
Then Justice D.K. Gupta of this Honorable Court. Malad, then Malad,
Where is the order passed therein?
Then Malad, they are directed to consider my case.
Where is that? Let us
That
see
is, I'm sorry.
81. Before WPST 803 of 2001, you have filed a writ petition.
Malad?
Before WPST 803 of 2001 also you have filed a writ petition.
Yes, Malad. And the Justice
Where is
D.K.
that? Let
Gupta,
us
I'm
see.
sorry, Malad,
Let us
Justice D.K. Gupta was pleased to direct to consider my case, Malad. Order was mailed on 5th September 1997.
Table 60 and page. '97. Same order. Same order. Please note file the correct. That also by diverting from the state. They are not selling. What is the, how much shortage of
1 year, no, 1 year, 1 month, few days. Malad, that is malad covered by the act. I am submitting malad
1 year, 1 month and few days?
few days.
From
And
where,
malad losses can come to my reply.
where is that? Where do we get this fact?
Malad, I have to state it. No, malad. That's not. No, no. Arey Baba.
8 years, 7 months, 15 days.
Yes.
Then it will be less than 2 years. It cannot be more than 2 years.
8 years,
8 years, 7 months.
7 months.
No.
Awareness said several husband malad.
After serving for 8 years, 7 months and 15 days.
Yeah.
So therefore much less than 2 years. About 1 year and he is correct. 1 year and 4.5 months.
Malad losses can come to my reply. Because malad I have filed malad reply at page. Malad they have
There is a shortage that is not in dispute.
malad reply.
But how, whether that shortage is to go against you or not, that is
Act
the.
has said he has to give it.
Huh?
Act. That is I have given at page 9 of my reply.
Act.
Act said, malad it was
Which
ordinance
act?
in 1982 and there is an act in 1983.
Oh, absorption. The taking over act.
Taking over.
What does it say?
Malad losses can come page 10 of my reply. Malad he has not given some page. It is missing from their affidavit. So I have annexed the full act in my reply. Not annexed full entire act.
Oh, from the date of vesting, it says.
Yes. Malad losses can come to section 4.
Yes, sir. We have seen 4, subsection 4.
Yes.
That is why we are saying.
Malad, then malad can come. I have worked malad. How many days?
No.
How many days? Then malad.
From the date of notification. Yes,
I'll
Mr.
actually take up.
Mukherjee. It says that the service will vest from the date of vesting. So therefore, if you take 20 years, he should suffer. He has to. The act says from the date of vesting. Come to 4.4. All right, we'll come back. You see 4.4. We'll come back.
wants to see the judgment order of Justice V.K. Gupta, and that is at page 26. Page 26, my lord. After the order of the Justice Umesh Banerjee, my lord, I made application, representation, then I filed it application. That is at page 26, my lord, type copy at pen 26A, type copy. Your Lord, directed to consider my representation. And now I am coming to the, my lord, Last have seen it, my lord, at page 26A. May I show the another circular of at page 16 of the my reply, which they have also annexed in opposition. Page 16 of my reply, my lord. And then I have given type copy in 16A. My losses can you see? Number 1, my lord, A. Name of the institution, Calcutta Homeopathic Medical College and Hospital. Date of taking over 27/12/1982. And date of acquisition 2/1/1992. Then come to the 4, para 4. Same, my lord. The past service will be counted towards the pensionary benefit only. Other condition of the service will be the same as applicable other government servants working in the same capacity. And losses can come to page 17. And this is, I have filed contempt application since they have not complied. And my lord, the losses can come to, then thereafter, my lord, I was given appointment. And the vacancies really last para, my lord. Mr. Moitro, last para of the last page 17, last para. Mr. Moitro, learned counsel for the petitioner, submits that the appointment letter received by the client without any signature of the concerned authority, so he could not join. It is further submitted that such a appointment without giving a retrospective effect would amount to further act of contempt. The read petitioner will be at liberty, my lord, then the read petitioner will be at liberty to raise this point at appropriate stage, but this court directs him to join the post in compliance of the order dated 20th April 2010, and this would be without prejudice to the right and contentions. Sir, liberty given to file the fresh Malaya. And lawsuits can come to finally.
This order is finally disposing of these proceedings.
My lord, that is my lord, in my WPST, earlier WPST.
803.
Yes, my lord. That is my lord. And well, the lawsuits can come. And
So final order has thereafter been passed in 803 on 22/2/2005. No. Yes.
But thereafter, I file contempt, and that is ordered in contempt in WPST 803. That is at page 17. My losses kindly come to their opposition.
WPCRC is what? Contempt?
WPCRC.
CRC.
CS.
CRC.
CRC. The losses kindly come to either in the petition or their opposition. Order of the director. Writ application, my lord.
So the date of taking over of your college is 2/1/92.
92, and I was appointed in 81, my lord.
You were appointed in 81.
October 1981. আপনি এখন বসুন।
15th October
1981. Now, my lord, losses kindly come to the order of the director.
No, first show us the where was that Acquisition Act?
Acquisition Act, my lord, as per the these, there will be, my losses can come to my reply. Act. Separate notification will be issued for the acquisition of the institution, section 4 at page 10 of my reply.
83 Act.
Yes, 83 Act. The state government may, if it is so thinks, may take time within a period of 9 years, referred in the subsection 2 or 3, acquire the institution by notification. So that is acquisition in 1992, also has seen it in India. It is also in the opposition, my lord. It is also in their opposition, but they have not annexed all page of the
So this was the act. It contemplated that taking over of the management and subsequent acquisition of the hospital.
Yes.
Subsequently.
And all the passages
Within 9 years from the date, within 9 years.
9 years. Can you come to page 23 of their opposition?
Just let us read the act. We are reading, don't worry, we are reading.
Section. So section 3 also, madam. It starts from section 3.
So this absorption was directed in the favor of the other person in 1986.
Was given appointment, my lord. That is at page 50.
No, but the taking over was in 1992.
92. Before that, he was regularized. And same order was in my case, my lord, considering that judgment. Considering that judgment. I also said, my lord, give me submit. I filed it. Justice D.K. Gupta directed to consider. That is, my lord, not allowed. Then I have to go tribunal again, my lord.
No, this is under the Homeopathic Central Council Act 1973. This is not under the in view of the takeover.
That is one of the I applied as per this year, my lord. That is my previous read drafted by the other advocate, not by me.
No,
That
no,
is,
no, no. You are relying upon some case of somebody else decided in 86. Who is that gentleman?
that is at page 50, just.
That is at page 50.
50.
Now you come to page 52. This is of 86. That day the college had not been taken over. Only the management had been taken over.
Management has been taken over.
Yes.
An acquisition in 1992.
92.
Even then he was regularized.
No, no, you see the order.
Same order and
it is an agreed order, correct?
And council
No, the petitioner so and so be absorbed as medical officers according to the Homeopathic Central Council Act 73.
73.
This is not under the
For
acquisition.
payment, only payment.
Huh?
For payment. For payment, my lord. And thereafter, the college authorities are further directed to issue the formal order of absorption in pursuance to the order passed by the Honorable High Court within a fortnight.
Correct. So this is not under the acquisition act.
That
This is not
But
under the.
this order was relied in my case, my lord, in 2005, my lord. In
When you
WPSC.
filed the writ petition in 1998 and 1988.
88 to consider my case also same ground, my lord, than PA.
That writ petition is bearing number CO. What is CO?
Sure, civil.
Oh, after the rule was issued, then it became a writ petition.
Yeah. Last second, CO, then my lord W. CO, then W, my lord.
CO W within bracket W.
And if rule issue, my lord, CR. CR, then W. Civil order. Q. Previously, it was
Mandamus.
No, my lord. Civil order.
Oh, like a
In
revision,
civil division. In
like
civil,
a revision.
civil division. Previously, it was, my lord, under section 115 of the CRPC.
227, yes.
100 feet of CPC.
Yes, after the amendment under 227. Yes. Yes.
115 for district court only, my landed district court. One.
And second writ petition is 803. WPST.
WPST against the order of the tribunal, my lord. Landed tribunal.
So in that the direction was given. Then he has been pursuing it since 88, 97.
And my lawsuit can be 1 point, my lord, that is clear, your lawsuit. My lord,
And after
at
that-
their opposition and in reply, in my writ, I have annexed the order of the director. The landed tribunal, previously there is another case, landed tribunal directed to consider by the director of the homeopathy. He has rejected my prayer. That is rejection order, lawsuit can see in his opposition or also in my reply, in my writ application. Opposition lawsuit can see at page 23. Page 23 of the opposition. Page 20, my losses in it. My losses can come to last para of the first page. Is uncontroverted by the petitioner that the compliance of the order passed by the Honorable High Court dated Atho, a WPST Atho, the Joint Secretary Ayush Branch Government of West Bengal issued a memorandum such and such dated Atho, 20th April 2010, through which the government was pleased to appoint the Dr. Satynath Samant with effect from the date of his joining as a medical officer of the Calcutta Homeopathic Medical College and Hospital temporarily for the period of 6 months pending police verification, medical, that is not formally a medical. Next para losses condition. The petitioner was also admitted that is not, he said admitted. Since the acquisition of the Calcutta Homeopathic Medical College and Hospital, he was not employed in the institution. So, that is also 1992, I have completed 12 years service. 12 years service, I was not, actually I was working. My payment was stopped. I then started my.
When your payment was stopped?
After 1992, they have stopped my payment because mine was not regularized that stage. So, my past service is 12 years. Acquisition in 1992. So it is admitted position. I have worked up to the acquisition. So gap is, my lord, 1 year and 3 months something, my lord.
So from 92 to 2010, you were not being paid?
Not paid. Then I have to come 1988. Then, my lord.
For 18 years.
18 years, I'm from several times in tribunal and before this. And last order passed, my lord, by this honorable landed tribunal by administrative member, landed administrative member. There is no judicial member last 2 years in the SAT, my lord, state administrative member.
And the order impugned, what does it say? Tribunal's order?
That is at last.
It is only saying that there is a deficiency.
That is not.
Yes, Mr. Mukherjee.
They cannot take the point of the res judicata since this honorable High Court has.
Who is saying he's not?
And they have not taken. They have not taken.
You are giving him ideas. You are giving him ideas.
We have friend in outside.
Yes.
Muslim friend in outside.
That is a very common thing, yes.
And there's a true judgment of the Supreme Court, and then that will place or not matter.
What judgment? Show first.
Staff service will be counted, matter.
Yes.
Even temporary service. Even temporary service. This. Okay. 1996 Supreme Court 2983. 96 Supreme Court 2962. Here's a good case. High Court. Last para, last excellency, last para. Last two para.
Sir, there was a government circular which said that all persons who were rendering temporary service, their past service will be counted. So that fact is not here.
Also, Gujarat High Court also said same.
Those are in the facts. They are there. The government decision. There was a government decision. That is not the point.
The act is clear here, man. Act and the that's
Yes. He is relying on the Act 83 Act. He says it was a management was acquired in 83 itself. In 92 it was the college was acquired. Acquisition in 92. Management takeover in 83. Acquisition in 92. He says I continued till 92. Since 88 I have been demanding regularization. Since 88 he has been demanding. There are at least two orders of the High Court. One is of the year 88. The other is of the year 2001. Now, both are in spite of these two orders. The order passed in 803 of 2001 is in 2005. Even after the court passed the order, it took you 5 years to issue the appointment letter. You have finally issued it in 2010. '70. Why? No, he says by coming into effect of the act and after the acquisition of the college, his services vested and he was to be deemed to be a state government employee under section 4 of the act. In spite of that, you have not allowed him to work for 18 years. Twice he has approached the court. When the court has passed order, you did not comply. In contempt, you were compelled, then only you complied by issuing an order. So you have kept him away for about 18 years. Correct. That we have understood. But why he was appointed in 2010? Why? So how the post became available? So why did it take you 18 years to do this? No post was created. It was just shifting of a post from there to here. There is no creation of post. Your financial, there is no fresh budgetary allocation. There is no fresh sanction of the post. The existing post out of 545, one has been sent to the college. Only under duress of contempt you have done it in 2010. No, the High Court said you go and join. All this you can do it when you want. He was raising this issue that there is no retrospectivity. The High Court said you don't raise this issue now, you go and join. All this, it will be available to you.
At page 17. At page 17 of the report.
Reply.
Seventeen.
So he is not without demur. On the at that very instance when he was issued the appointment, he said that there is no retrospectivity. He has raised this issue before the court immediately. Yes. All right. So that is your submission. Very well. And just before that, where is this order of 20th April 2010? 17? No. 20th April 2010. The appointment order. 17. 7. Oh yes, you have just shown this. Yes, all right. Yes, that point you have said that he did not, he took it, he could have challenged it, he has not challenged it. Now what else? Four two five. 425. Yes. That you have already, that you have said. Yes.
After 8 years and after 10. Waited.
Where is that first way he has filed? Order passed in the first way, directing the state government to consider. And what is the date of his retirement? 2018.
December 2018.
How much?
31st December 2018.
Yes, he is not asking for those things. He is only asking for pension. So this writ petition he had moved prior to his retirement. This writ petition he has moved prior to his retirement. Yes. That you have said, but this he has moved prior to his retirement. He is retired in it. All right, that you said. So which benefit is not admissible to him if he gets pension? Double gratuity. Yes. That's all. Twenty 2023. Double gratuity. Yes, that's all. Six four. How six is relevant? Six is not relevant. That you have already said. Yes. All right. Estoppel against the statute. You are arguing estoppel against the statute. Then yes. And therefore, if he is there, it is now he is stopped. There is no question of limitation. Anyway, that is your subject. The basic requirement is of a qualifying service. The basic requirement is of a qualifying service. The qualifying service is 10 years. And that service has to be as a government employee. He becomes a government employee by effect of section 4 subsection 4. On the date of acquisition, he becomes a government employee. How it cannot be? That is your act. That is a statutory mandate. That is a clear intention of the statute in explicit express terms, that as on the date of acquisition, all the employees shall vest. And if you take years to issue an order in compliance thereof, then who is to suffer? And such a plea you are taking advantage of your own delay or lapses. What does the apex court say? That is all right. That is all right.
In respect of the section 4, subsection 1. One more. That is one in respect of the purport.
That doesn't affect. From you are reading 4.1, but 4.1 cannot be read in isolation. That 4.1 occupies the field insofar as encumbrance is concerned. 4.4 occupies the field insofar as the employees are concerned. So therefore, they can both exist parallelly. They are not in conflict. What is? That is a liability under the statute. It is not your case that he was part-time. It is not your case that he was overage. So this is not applicable. Then what is applicable? Who has been an employee before the date of vesting, that is admitted. Shall on and from the date of vesting become an employee of the state government. It does not contemplate issuing any notification. It does not contemplate issuing any appointment letter. Nothing. It's could have been, but this is the statute. Statute will not change. Statute remains the same. Therefore, we asked you, are you arguing that there is a stopple against the statute? So is he stopped from arguing that now? All right. Your act you don't know. Act passed by you, you do not know. And your legislature has given a mandate, and you will just by not doing anything, you will obviate the intention of the legislature. Then that is what is happening in this case. You have taken 18 years to issue the order, and then you are saying why he has come after delay. See this 2009 Supreme Court. Have a look. Have a look what the apex court says. 2009 3 SCC page 90. When the state is delaying or for the wrong or the lapses on this part of the state, can you argue that he should suffer. That is precisely what you are doing. In this case, unfortunately, that is what you are doing. Very well, we have heard you. The We have recorded all the submissions. It will come for orders on 11th April. Over. We have recorded that parties have been heard. Not to?
Number 25. Number 4.
Earlier we have called matters first. That's been called for.
Your Lordship, I am for the petitioner in this matter. I am led by the learned additional Solicitor General. He was here at 2 p.m., Your Lordship, but right now he's in some difficulty, Your Lordship. Your Lordship, he is humbly requesting if the matter can be heard on Tuesday, Your Lordship. Fixed charge?
2 p.m.
2 p.m., sir.
Ninth. Please inform him that it's 9th. 9th.
Your Lordship, my learned friend, I wanted to request him to match the page numbers of the petition because it was not matching, but he's not cooperating, Lordship. Your Lordship, the condonation of delay application.
And condonation application was supplied to me. They referred the annexure, but no annexure was made.
Your Lordship.
In my lord, the evidence was upon. So, my lord, the submission was there. All is black.
Your Lordship.
How I will deal with the matter?
She is not saying that everything is all right. She is not saying that everything is all right. She is only asking you to cooperate that so that she can set things right. So let her give you a copy. Why to make an issue of this in court? You settle it between yourself.
Your Lordship.
Who is saying not to supply? Who is saying not to supply?
Complete copy.
Your Lordship, may I clarify, Your Lordship?
Yes.
Your Lordship, the railway authorities, my clients, they have supplied us with a copy of the condonation of delay application without the annexures, Your Lordship. Now, Your Lordship, if they have supplied it without the annexures,
Whatever you have, it must be in the same order.
yes,
That's
but
all.
I am humbly requesting my learned friend to kindly just match the page numbers with my petition.
Why are you telling us?
Because he's not cooperating, Your Lordship, and then that will create problems for Your Lordship while the matter is being heard.
Copy, I will accept that.
I have given you whatever my clients have supplied to you.
Okay, they should give you something which they have not filed. Mr. Counsel, whatever they are filing, they will give you. They will not give you excess of what they have filed.
I'm grateful.
If that is insufficient, we will see.
I'm grateful.
That is not a thing to be submitted in court. It is a very standard procedure that whatever they will file, they will serve on you. If they file things in a mess, then it will be in a mess for you also. It can't be any better.
I'm grateful.
If it is in a mess, we will see what is to be done. We will see
But
what is
in
to be
the
done. You
meanwhile,
can't
kindly
refuse
let
to
me
accept
check the
that.
page numbers.
You can't refuse to accept that. You can't refuse to accept that. Whatever they are filing, you can't refuse to accept. If it is not in order, that we will see. You accept it. Yes.
Your Lordship, I just want to match the page.
Do whatever you want to do. Don't tell us.
I don't have a fresh copy. I'm sorry.
Call the list.
Your Lordship, this is harassment. He's saying, please supply a fresh copy.
Call the list.
Here. Really?
What notes of argument, sir? We are trying to make sense of the things on the last 2 days.
I gave leave for filing. Your Lordship said, all right.
Yes.
Yes.
You have filed it.
No. Today I'm made it ready.
They have argued thereafter they have filed. We are waiting for you to argue, then you will. No document beyond the file we will take in the notes of argument. Not one document beyond the file we will take. Whatever was before the tribunal, beyond that, not a single document we will take. Be very clear, we will record. Of the? Then show us from the why. Let us see, then you file it, whatever you want. First show us. First argue your case, then you file your written notes. You can't just file your written notes and go. Not here. He must have. Then they told him that the other case is called. He would have said then. Even diesel and electric. You cannot conclude in 10 minutes. We'll take it up on a different date. Yes, take down. Take down. Due to paucity of time. Call the next. We'll see. Yes, call the next case. Let us see, we don't know. On that day you mentioned. On that day you mentioned, we'll see what is the position.
Item number 25.
Same reading could be. You have to be bowling. I'm not. I did not.
ये 20 application lagi 25 मैं अब petition है my lord evident reply my lord এই যে
You're filing a reply.
reply my lord
Yes, give.
Petitioner is working as a sweeper on casual engagement my lord, since 1998 my lord. Page 28 for a moment my lord. Page 20 of read petition my lord.
Working as a
No my lord, no part time my lord. Was sweeper
since when?
since 1998 on casual engagement my lord.
Where?
Since 1998
Where?
and that my lord, fishery department
Fisheries Department.
director of fisheries. In 1998 my lord. Still is working my lord.
From 98 till date.
Till that my lord.
So what does she want?
Higher wages my lord. Higher wages.
Higher wages.
But for the moment page 20 for the moment my lord,
Higher wages under which scheme?
my lord, in terms of the notification my lord, with the
That
supplementary
notification regarding security of tenure.
but according to my notification, the lordship for moment for page 28 my lord, the office memorandum says according to this memo my lord, the petitioner was entitled to higher wages.
Page 28.
28. Page 20. Entitlement of higher wages and other benefits in terms of finance department Unanimous assurances in favor of Srimati Chameli Das, sweeper working on casual engagement since 1998.
1990.
98. 1998. Accordingly, my lord, Joint Director of Fisheries, my lord, wrote a letter to the Director of Fisheries, my lord. Included herewith copy of the above entire, my lord,
This is not the notification. You are seeking benefit under which notification?
but this is the notification, my lord.
This is not a notification. This is a communication.
Supplementary, my lord. Supplementary, my lord. Apparent supplementary, my lord. Depending in the reply, you will get his lordship. In the reply, may annex this notification.
Give us whether it is in supplementary reply. Tell us once. Which one?
But in reply, let us get it. In
Which
reply,
page?
page number 4, my lord. Page number 6.
No, that is why. So what they have done?
Yeah, but thereafter, my lord, I made several representations.
What have they done? They have rejected by which order?
We my last order, my survey, my lord.
Not OA, sir. They must have rejected. Authority must have rejected.
They have rejected my suborn, my lord. My lord, page number 44, my lord. Page number 44.
41.
44. You're saying I'm a part-time sweeper. Law officer and you of Executive Secretary to the Government Wisdom.
Earlier also it was rejected.
No, but this is first time.
That is all.
That is it. Again, the way also, my lord, the state government appeared, but they find opposition, my lord, and on this basis, the tribunal also passed this order relying upon this.
Yes. What is the difference between casual, daily rated and part-time? Working for more than 8 hours. From where do we get this distinction? No. That is in your order. But the memorandum of 23/4/2010, they are relying upon that. It says casual as well as daily rated. It does not only say daily rated. Page. Yes, it is the same thing, 23/4/2010. It says daily rated and casual both. It does not say only daily rated. Casual, how? What is the distinction between casual and a part-time? From where do we get this distinction? Daily rated we can understand. That means on a daily wages. Casual is not daily wages. That is another ground. Sanction post or no sanction post is another ground. Yes. And the recommendation which has been sent by the assistant director, he says he has been working in 240 days in every year. Yes, he has said so. We have what records? Which record has been considered? Available records mean which record? Page 28 is the recommendation made by the joint director. See what he says. Third paragraph at page 28. Now, in terms of finance department GO number referred above, since she has been rendering service for at least 240 days in each year, is entitled to considered for getting the benefit of remuneration of minimum pay. So what record he has considered? This is the recommendation. Then how the consideration is contrary to this? Really see. Take it up Monday.